You're up, Mr. Cosden. You need to unmute.
Good morning, Your Honor. Can you hear me?
We can.
May it please the court. Before the court this morning is James Moore versus State, case number 19-0080. My name is Christopher Cosden. I represent Mr. Moore, who is the defendant below and is the appellant in this court. I would ask to reserve 5 minutes for rebuttal. May please. Your Honor, there are two problems with this case. There was an issue, which is reversible error, about admissibility of evidence. There was also an issue about sufficiency of the evidence. I will address the admissibility issue first. Hearsay evidence was admitted under 90.803 paragraph 23, the child abuse hearsay exception. Now, the court's order, which came about as a result of a pretrial hearing on the state's notice, admitted the child abuse hearsay. That ruling was error for two reasons. First off, the statements that were admitted were by a child named J.C., who was the complaining witness's grandson. The out-of-court statements by J.C. that were admitted related that the victim of the events, which J.C. described, was not J.C., but instead J.C.'s grandmother, the complaining witness. Now, the plain language of 90.80323 is neither equivocal nor hard to understand. The plain language of the statute requires that the child abuse hearsay exception applies to statements made by the child victim about victimization of that individual. In other words, the child can testify about his or her own victimization, but not victimization of somebody else. The Supreme Court told us that in State versus Dupree, which is cited in the briefing. The Supreme Court told us that while we agree that a child can be abused by what the child witnesses and thereby be a child victim, for hearsay statements of the child to be admissible under section 90.80323, the prosecution of the defendant must be based upon the victimization of the child whose statements are being related. Very clear and succinct ruling by the Supreme Court. This court cited that ruling in a case called Allison versus State, which is also cited in the briefing. This court held that in order for a child's out-of-court statements to be admissible under section 90.80323, the prosecution of the defendant must be based on the victimization of the child whose statements are being related. Okay. That is not really disputable. I suppose one could dispute that if one wanted to, but both the Supreme Court and this court have stood by that ruling. So here, the victim was not the child. The victim was Ms. Jackson, the child's grandmother. So the trial court misapplied 90.80323 and allowed those statements in.
Well, Mr.
Now,
Costin, let me ask you this. There was a child neglect charge in this case. And the evidence that came in from the child was his statements to the neighbor about what was going on at the house. His grandmother was being attacked and so forth. How do you separate that out, or can you separate that out from the child neglect charge?
well, Your Honor, even if JC were somehow the victim of a neglect, that still doesn't.
Well, the jury, he was charged with it and the jury found him guilty of it.
That's true, Your Honor. But even if that were true, even if that happened the way that the witnesses said that it happened, and even if the 90.80323 evidence had been admissible, it was not admissible for a second reason, and that is that neglect must be an act by a person who is a caregiver for the child. That is clear from the statute. If we look at 827.03, we see a definition for neglect, and neglect of a child under the statute involves a caregiver's failure or omission. Now, the statute also defines caregiver at 827.01. Caregiver means a parent, adult household member, or other person responsible for a child's welfare. Here, there was no evidence at all that the defendant in this case was responsible for the child's welfare. In fact, the evidence was that he was not responsible for the child's welfare. He and the child's grandmother had had a fight several weeks prior. The grandmother had apparently asked the defendant to leave the house, which he did. Then she invited him back. When she invited him back, she was present and JC was present, but there was no evidence at all, any place, that the defendant was a caregiver at that.
Okay, so then back to my question, though, let's assume hypothetically that the evidence would have supported a determination that he was a caregiver to the child. Are you suggesting that the child's hearsay evidence was properly entered for purposes of, at least for the child neglect charge?
No, Your Honor, it was not.
Okay, so how do you separate that out from, again, how do you separate out the child neglect charge from the other charges as it relates to the child hearsay in this case?
Well, the child neglect was based, at least in part, on the 90.80323 hearsay evidence. If the 90.80323 hearsay evidence had not come in, I don't know how it would have been possible to prove up the neglect. The neglect, such as it was, involved a dispute between the adults in the house.
Well, the adults testified that this child witnessed this armed conflict and this beating. Well, one of the adults testified to the beating and ran from the house unsupervised. So that did not require the child's testimony to come in, and certainly that foundation was already laid.
In Dupree, the Supreme Court told us that a child can be abused, or I suppose neglected, by what the child witnesses, that is not sufficient for hearsay statements of the child to be admissible under 90.80323.
Mr. Condon, what about as an excited utterance?
There was no predicate for an excited utterance, Your Honor. The events, the hearsay that was repeated was a considerable time after the events that were related. There's no evidence.
I don't know. Was there any evidence about how long? Though I don't think there was any evidence that at least was mentioned in the briefs about how long after this was. I think that did this woman live on the next street over? Is that what I recall?
I don't know if it was the next street over. It was certainly within walking distance, but we do not know at exactly what time JC left the house. And we don't know at exactly what time he arrived at this woman's residence.
But at the time he left the house, the fracas was ongoing. So,
well, actually, we don't know exactly when he left the house, Your Honor. The adults who were there noticed that he was gone at some point after he left, but we don't know exactly when that was.
The brief state that the state filed a notice of intent to introduce a hearsay for spontaneous statement, excited utterance, and statement of child victim. Do you dispute that?
No, Your Honor. That's what they said. At any rate, Your Honor, the other major issue with this case is that the defendant's motion for judgment of acquittal was improperly denied. Amongst other things, the defendant was charged with burglary. Now, we know that burglary is a specific intent crime, and we know that one of the elements of burglary is that at the time of the entry, the defendant had the specific intent to commit some offense within the place that was entered. Here, there was no evidence, absolutely none, that the defendant had entered with the intent to commit a crime. The defendant testified quite clearly that he went into the dwelling to look for his keys. He had been properly and by invitation in the dwelling earlier that evening. He had apparently lost his keys at some point. We still don't know when or where. And he wanted to look for his keys. He had asked to be admitted to look for his keys. He was denied admission. He spent the night in the shed. He came back the next morning and again wanted to look for his keys. He needed his keys because he needed to drive his car to work. The defendant's testimony was never rebutted or refuted. Nobody said that the defendant claimed to have entered the dwelling for the purpose of committing a crime. That simply is not in the record.
Well, the state relies on the presumption in 1807 of stealthy entry.
There was no evidence of a stealthy entry.
Well, he didn't knock on the door though, correct?
Well, actually, he called by telephone 3 times.
And she didn't answer.
Well, I can't.
But then he didn't knock on the door. He took a slider off its rail.
He did indeed. Probably all of us have had the experience of entering some place where we had every right to be by some unusual means. And that would be indicated if one were locked out. Now, the trial court, when it denied the defendant's motion for judgment of acquittal, said that prying a slider off a runner is not normal entry into anybody's home. The trial court ruled that the defendant entered, quote, in a way that's not normally used to enter a residence, that is a burglary and prima facie evidence that you intended to commit a crime inside the residence. Well, that's simply not what the law is. A stealthy entry, which this was not, could be circumstantial evidence of intent to commit a crime. But
well, it's under the statute, it's presumed, right? Correct. It's presumed that that's the case.
Your Honor.
Or prima facie, it's a prima facie. Anyway, you're down to your 5 minutes, Mr. Cosden, so use them as you please.
Well, here the entry, Your Honor, there was no evidence the entry was stealthy. It was done in broad daylight in front of anybody who might have been watching, and the defendant admitted to a police officer as soon as the police arrived that that's how he had entered. So if the court has no further questions, I would ask to reserve the remainder of my time for rebuttal,
Sure.
please.
You have 4 minutes.
Thank you.
Good morning, Your Honors. My name is Jonathan Tannen, representing the state of Florida. On the issue of the motion for judgment of acquittal, this court has held that evidence of intent must be determined from the surrounding circumstances, that intent is a jury question, and that intent is rarely, if ever, a basis for a motion for judgment of acquittal. And in this case, even leaving aside the statutory presumption, there was sufficient evidence for the jury to find that Mr. Moore entered the residence with the intent to commit a criminal offense. The testimony was that the night before the assault, Mr. Moore stood outside the victim's home and screamed that he was going to kill her. Now, normally that might be hyperbole, but the testimony was that Mr. Moore continued yelling at her and cursing at her throughout the night. At one point, he went so far as to defecate outside and to use his feces to write a derogatory word on her car. And then the next morning, he broke into the house through the back door, through a sliding door in the back, armed himself with a gun from the garage, went into the bedroom where she was sleeping, and the child was also sleeping, took her gun that she had, beat her with both guns, and told her that he was going to kill her. Under these circumstances, a rational juror could find that Mr. Moore meant what he said, that he intended to kill her, and that when he entered the house, that was his intent. And
Mr. Tannen, didn't she also put him on notice the night before? She did not want him in the house, and that she had a gun, did not want him coming in?
That's correct, Your Honor. Earlier in the evening, Mr. Moore said that he wanted to come into the house to get his keys, and Miss Jackson locked the door. She told him he wasn't to come inside the house, and she told him that she had a gun and that she was armed. And the other basis for the denial of the motion for judgment of acquittal, in addition to the evidence, was the statutory presumption, as Judge Northcutt raised. The rule is that, or the statute states that in a trial on the charge of burglary, proof of entering such structure or conveyance at any time stealthily and without consent of the owner or occupant thereof is prima facie evidence of entering with intent to commit an offense.
I'm glad you pointed out that presumption was my phrase, not the statutes, because the presumption would not be accurate.
Well,
by showing stealth, the state made a prima facie case.
Correct, Your Honor. And in this case, the evidence showed that he entered through a sliding door in the back. He had called Miss Jackson earlier that morning and said he wanted to come inside to get his keys. And she told him to go away. He had kept her up all night and she was going back to sleep. And sometime after that, according to the defendant's statement to the police after his arrest, that call occurred at about 8:15 in the morning. And we don't know exactly what time the break-in occurred, but the defendant indicated that it was after 9 o'clock. So this was approximately an hour or so after that conversation when Ms. Jackson told him that he was going back to sleep. And
even if he had been, if she was fully aware at the time of his entry that he was attempting to enter, isn't the stealthiness as against the world? Could it be as against those who may be observing the house from outside, as opposed to just the victim occupying the structure?
That's correct, Your Honor. And in this case, the door was in the back. It was a sliding door that went out to a screened-in back porch. So this wasn't something that was visible from the front of the house.
So he could have been utilizing stealth so as not to be detected by those outside the structure, even though assuming she was awake at the time, which seems she wasn't, she was fully aware that he was breaking in.
That's correct, Your Honor. And as far as the trial court's use of the phrase "not normal" when it was denying the motion for judgment of acquittal, it does seem from the record that the trial court was referring to the statutory presumption. None of the attorneys argued in response that the trial court was applying an incorrect standard, and that conversation took place immediately after the jury charge conference where that instruction was included in the burglary instruction. So it seems from the record that the judge was referring to that statutory presumption. And of course, even if it wasn't, under the Tipsy Coachman doctrine, this court should affirm, even if the trial court, when the trial court reaches the right result, even if it's for the wrong reason. And in this case, for the reasons I've discussed, the evidence itself, as well as the evidence satisfying the statutory presumption, the motion for judgment of acquittal on the charge of burglary was correctly denied. On the second issue, the admission of child hearsay, I would first point out that there were two statements. There was the statement of the neighbor, Miss Wark, and the recorded interview that was done by the child protection interviewer, or rather the special cases interviewer, Miss Snyder. With respect to the first statement, the trial court also ruled that that statement was admissible as an excited utterance. The child was hysterical and crying, according to Miss Wark's testimony. He said that his grandfather was holding a gun to his grandmother's head. He repeatedly asked if his grandmother was dead. And the trial court, on that basis, admitted the statement from Miss Wark under the excited utterance exception. And in the initial brief, that statement has not been, or that ruling rather, has not been challenged. So as far as the admission of child hearsay, we're really only talking about the recorded interview to Miss Snyder. The evidence did show that the trial court correctly admitted that statement. The defendant was charged with child neglect based on the victimization of the child from the events in this case. In Dupree, the issue was that the defendant was not charged with any criminal act against the child who was testifying as the child witness. The defendant in that case was only charged with a criminal act against a different child. So in this case, the child was a victim for purposes of the child hearsay exception. With respect to the issue of whether the defendant was a caregiver, that issue was never raised below at the child hearsay hearing, and therefore this issue is unpreserved. And subsequently at trial, the defense conceded that Mr. Moore was a caregiver to the child, as all of the evidence suggested. That was part of the basis for the motion for judgment of acquittal on the charge of burglary, that Mr. Moore had raised this child, that he was a caregiver to him, and therefore, according to the defense's argument, he was allowed to enter the house. So the issue of caregiver was never in dispute in this case. And Mr. Moore himself testified that he had raised the child and that the child, he was financially responsible for the child, and the child considered him his grandfather. If the court has no further questions, I will rely on the state's brief for any further arguments and request that the judgment and sentence be affirmed. Thank you.
Thank you, Mr. Tannen. Okay, Mr. Codson.
Yes, Your Honor. 2 points. First off, even if the defendant had been a caregiver at some time, certainly after he was ejected from the house and told not to come back by, excuse me, by Ms. Jackson, he was not a caregiver at the time the statements, the hearsay statements were made. I don't know how it would be possible to discern that he was a caregiver if he wasn't allowed in the house. The state properly concedes, I think, that the child's statement to the CPT interviewer was not properly admitted. That certainly was not within within the excited utterance exception. And applying again 90.80323 to that, we do not have the proper predicate. So I would ask that the
Let me just ask Mr. Tannen, is that accurate?
No, that's not correct, Your Honor. The state's position is that both statements were correctly admitted under the child hearsay subsection.
Okay.
Go ahead, Mr. Cosden.
Okay. I would then renew the all of the previous argument about the child abuse exception. Certainly the concession that the CPT interview was not at a time when the child could make an excited utterance. So I would ask the court to reverse the convictions and remand the case for a new trial.
Okay, thank you both. Mr. Cosden, you are going to leave the Zoom session by clicking the leave button in the lower right-hand corner of your screen. And Mr. Tannen, I think you're going to stay in so that Mr. Roscoe can come in, correct?
Thank you, Your Honor.